Hi guys, so let's start with case study number 15. Okay, so let's see the first question. Yes, for the initiation of corporate insolvency resolution process against BSPL, IPPL can file an application to NCLT jointly with. Okay, so there is no such need for filing a joint application if you are an operational creditor. The payment to whom has been defaulted by the corporate debtor. So if you can see, IPPL started delivering the requisite material. This is from the case study. IPPL started delivering the requisite material to BSPL for setting up factories. However, BSPL was not convinced with the quality of the material and withheld the payment of money to IPPL. Okay, so BSPL did not pay money to IPPL, and IPPL contested the same and sued BSPL in the court of law for non-payment of money. BSPL's contention was that since the material supplied did not meet the specified quality, it was now not liable to pay IPPL for the same. Okay, so it is established that BSPL has defaulted on payment to IPPL. It is another matter that BSPL has some issues regarding the quality. We are just asked whether IPPL can file an CIRP application, initiation of CIRP application, and whether it has to file it jointly with any other person. No, it can file alone. That is option D is the correct answer. IPPL can file an application solely only and not jointly. Okay, so joint application is not allowed. IPPL has to file an application for initiation of corporate insolvency resolution process solely only. Okay, next question second. The committee of the creditors of BSPL would comprise of. Okay, so as you know, the committee of the creditor consists only of the financial creditors. Okay, and all those entities which are related parties but are financial creditor will be excluded from committee of the creditor. So we have to see, yes, we have already established that IPPL has provided some material. So IPPL is not a financial creditor, it is an operational creditor. So IPPL, this option is incorrect. We have to see what is UCL. So for this we have to refer the case study. So if you can see, BSPL, that is the company, approached the Uniform Finance Limited UFL for this purpose, and it submitted an application to UFL requesting for rupees 100 crore as loan. UFL agreed to facilitate the lending as a secured lending to be repaid in 40 AMIs. So UFL has given a loan to BSPL. So you may be confused that what is the difference between UFL and UCL. So for this, UFL was a part of the Uniform Industries Group. The group had another entity known as Uniform Capital Limited. USL was also involved in finances and had a larger client base as compared to UFL. So UCL is a much larger company than UFL. The group was desirous of merging UFL in UCL to further expand its client base under one umbrella in the UCL. The petition for the merger under consideration in the High Court, and High Court approved the same. Okay, so there is a merger between UFL and will be considered as a financial creditor as they have given a loan of rupees 100 crore to BSPL. So UCL will be 100% part of committee of the credit. So UCL, so we have to choose between these options. BSPUL, so if you can see, BSPL had also taken a loan in the form of rupee denominated bonds from Bindal Steel Power USA Limited, that is BSPUL. Though BSPUL was a group entity, the loan was taken at an arm's length price. So they have clearly mentioned that BSPUL is a group entity, that is a related party to BSPL, which had provided loan. So BSPUL will not be part of COC because it is already a related party. So option D is the correct answer, because BSPUL is the related party, IPPL is an operational creator. So option D is the correct answer. Only UCL would comprise of COC would comprise of UCL. Next question third. Assume that there are no legal proceedings going on between IPPL and BSPL, and the NCLT admitted the application filed by IPPL for initiation of corporate insolvency resolution process against BSPL, but immediately thereafter IPPL and BSPL came to a satisfactory settlement. In such a case, application to NCLT. Okay, so here the application for CIRP has already been admitted by the NCLT, and they are asking, after the admission of application, these two both parties, that is IPPL and BSPL, have came to a satisfactory settlement so they wish to withdraw the application to NCLT. Can they withdraw? So this is the similar question which was asked in the previous case study. So this is a question of withdraw the application after the NCLT has admitted it. Yes, it can withdraw the application, but only after the formation of COC with the prescribed voting share. So if you can see, option B is the correct answer. That is that 90% rule. That is, it can be withdrawn by IPPL after admission subject to the approval of committee of the creditors with prescribed voting share. So if 90% voting share is acquired in COC meeting for withdrawal of the application, then they can go ahead and withdraw the application, but they require the 90% approval of the COC. So option B is the correct answer. Yes, it can be withdrawn by IPPL, but only after approval of COC with the prescribed voting rights. Okay, so option B is the correct answer. All other options are incorrect. So if we have to just read, can be withdrawn by IPPL, no, this is also wrong. Not financial creditors but COC. Can be withdrawn at any time with the approval of NCLT by IPPL, no, this is also wrong. So only B is the correct answer. Option B is the correct answer. Next question fourth. Whether all-in cost of the debenture is within the prescribed threshold under FEMA. So you know there is a discussion regarding all-in cost. For this we have to refer the legal provision. So if you can see ECB framework guidelines, I have taken this information from the page 5.37 from FEMA 1999. All-in cost ceiling per annum is benchmark rate plus 4.5 basis point spread. Okay, so all-in cost will be equal to benchmark rate plus 4.5%. So for this we have to know what is the benchmark rate. They have given here that, yes, so if you can see, the 6-month NIBOR pertaining to New York Stock Exchange at the time of providing the loan was 3%. So this is the benchmark rate, and 3 plus 4.5% comes to 7.5%. Okay, so they are asking whether all-in cost of the debenture is within the prescribed limit. So 7.5% is the rate be considered as legal under the provisions of FEMA, because we have already covered here the ceiling. Okay, if you can see, all-in cost ceiling is equal to benchmark plus 4.5%. The benchmark is 3%. The ceiling 3 plus 4.5% is 7.5%. Let's see what is the actual percentage rate. Okay, so if you can see, BSPL required to deposit tax which is deducted source, etc. So if you can see, BSPL, in order to meet the expense for the working capital in relation to setting up factories in different locations of India, issued 6% debentures. Okay, so the actual interest rate is 6%. The ceiling limit, that is maximum possible interest rate, is 7.5%. Since the actual interest rate is within the ceiling limit, let's see what are the various options. Yes, so they are asking whether all-in cost of the debenture is within the prescribed threshold under FEMA. Yes, option A is the correct answer. Yes, because all-in cost is 6%, whereas the prescribed limit is 7.5%. So option A is the correct answer. Okay, next question, 5th. Which of the following is incorrect? Which of the following is correct? Sorry, which of the following is correct? Okay, so option, let's see various options. Raising of ECB through foreign branch of SBI bank is not valid because the foreign branch of an Indian bank cannot subscribe to the foreign currency of foreign currency denominated bonds. This is incorrect. BSPL has appropriately hedged the foreign exchange exposure as per the provisions of FEMA 1999. This is also incorrect. This is also incorrect. This is only correct. Okay, so second is correct because raising of ECB through foreign branch of SBI is not valid because the foreign branch of Indian bank cannot subscribe to the debentures, the funds of which are to be used for the working capital purpose. So for this we have to refer the ECB framework and guidelines. So they have clearly mentioned that ECB raised from the foreign equity holder for working capital purpose and general corporate purpose or for repayment of rupee loans. ECB cannot be raised from the foreign branches or subsidiaries of the Indian banks for the above mentioned purpose of working capital. That is, ECB cannot be raised from the foreign branch or subsidiaries of the Indian banks for the purpose of working capital. So this is the correct statement. So option C is the correct answer. So in this way we have completed our discussion of the case study number 15. I will be attaching the link of this PDF in the description box, so don't forget to check out the same. So thank you. Do share your feedback. Thank you.